for me mama kwaba biom the trending GH celebs so na say and then the high court or the trimu papa cry high court and then yenjeja no isan say Ato forcing and Jakpa nsem no ho and then na de ni atra say nsem ekoso bi na ye de eba beso Esan say, ni oti asemi so ya Justice Serwaa asaributwe ono notice ansem we so ewo high court then they really know or the insem aba no trim say application for mistrial filed by Dr. Ato and Jakpa has been dismissed by the court. Application for mistrial filed by Dr. Ato and Jakpa has been dismissed by the court. Not just say application na Jakpa any Ato filing nyina no chese abua tuegua and then no enije akọ ede ama MPP amenyoku no first thing any say that dismiss Ato forcing stay of proceedings. Dismiss Ato forcing stay of proceedings. The proceedings are oye nyina ne files are the buy nyina se ebeya court entwentwe ensem no fansan omo ntwe ansa omo yesi ansa ni nyina no Justice Serwaa ato ni nyina egu aboni nyina na osanso de advice de ma AG odame de ifutu bi ema no ne sansem no ye beko ni akwakotie na osanso sha ensema Jakpa ene ne lawyers file application the court betre Supreme Court say ebe Supreme Court embra sansem we mu na their high court for ye no omo nshadante ase ebe Supreme Court embra sansem we mu no mbehwe ensem ni mu ye emfama ono Jakpa ene ne lawyers no nti ye hwe se ende ya atemu aba aya to be ede ama Ato any Jakpa omo filing nano just say yaboni nyina egu no aso Supreme Court ebe dina ensema Jakpa ne lawyers no aka no de aye bibi anase empo no ombehwe high court rulings a eba abonten no na ebia omoso mabosansem na egu ana adofo no nsem no se ne ebedan bia no ye de ebeba besomo na Kwame Jan ede ono so na dwentre ne nsem bi egu akwemu amesre se ebekọ ne akwakuti ono so ne nsem a odi tudwan adofo no yenko ne nkoti nsem ne ntrem emfri Kwame Jan
of Abina Pokia Aka versus Agricultural Development Bank, which is a Supreme judgment, and then there is Raphael Kubaji. It's a famous case versus Maki Yabu Asari and two others. So these are Supreme Court judgments which have expounded the law, and the results from these two judgments is that when your communication is recorded secretly without your consent, it offends our laws, and there are serious restrictions as to the admissibility of such evidence, even during trials, because of the way these kinds of evidence have been obtained.
Right.
So, recording secretly the conversations with or of others without their consent, it is not just in this country. If you go to the United States, almost all the 50 states have laws which criminalize recordings without either the consent of one party or consent of both parties, except under very limited circumstances prescribed by legislation.
Well, Professor Jan, you speak to admissibility of this particular circumstance. Again, I want to find out from you that in as much as that could be argued, are there exceptions or some circumstances within which we find ourselves in under which these recordings might be considered legal or admissible in court?
So, for example, if the police, for some reason, are investigating a crime or suspect that a crime may be committed, they would go to a court of competent jurisdiction and seek leave of the court and obtain same and tap into your communications with leave of a court of competent jurisdiction. In that situation, admissibility should not be a problem. In other situations, our law, if you go back to our evidence decree, the evidence decree, which is now the Evidence Act, because of the Statute Law Revision Commissioners Act, is one of the best pieces of evidence decrees in the world, or evidence legislations in the world, because the drafters, led by a late Court of Appeal justice called Justice Serwaa, famous judge, they studied the evidence laws of almost every civilized jurisdiction and tried to find out what is the best practice before they created our own system.
Adofono Professor Kwame Jan Egusuni nsem so a o kan ye bekoso na yetie no na ehu nsem no eye.
Now, in American jurisprudence, there is a principle which is known as the fruit of the poisonous tree. It's one of the principles that applies in the law of evidence, which says that where a tree is poisoned, the fruits of the tree are also deemed to be poisoned. In non-legal format, it means that if evidence has been collected in a way as constitutes a violation of law or rights recognized by law, the evidence will not be admitted to establish the guilt of an accused person. But you made a point. There are circumstances under which that evidence may be admitted. And in fact, in the case of Raphael Kubaji versus Michael Yeboah and two others, the Supreme Court set out the parameters of admissibility and made provision for the evidence to be considered on its own merit, depending upon the gravity of the offense that is on the table. So the courts have a way of dealing with it, but the general principle is that where the tree is poisoned, the fruits are also poisoned. That's the general principle. But like all general principles, there are exceptions. There are exceptions.
Right.
But the exceptions don't become the rule. They remain exceptions.
Talking about these exceptions, are you able to elaborate further whether there are legal distinctions between recording a private citizen and recording a public official, as has happened?
Adofonom hanum ena mede ubesi ewo court insensem ni monsem foforo epie wo munso a mede eno nso ebeba besum. Until then no mesra obiom se oba like you oba share na wasanso a comment just AC any mede aha trending GS celebs makram.